Welcome to Civics in a Year, the podcast that makes civic literacy fast, accessible, and surprisingly engaging. In just 10 minutes an episode, we'll tackle one of 250 essential questions about American democracy, how it works, why it matters, and what it means for you. Whether you're a student, a teacher, or just someone who wants to better understand your country and your rights, you're in the right place. Civics in a Year is powered by the Civic Literacy Curriculum from the Center for American Civics and is produced in partnership with the School of Civic and Economic Thought and Leadership at Arizona State University. Welcome back to Civics in a Year. We today are talking about the Supreme Court case Schenck versus the United States. This happened in 1919. The case is on freedom of speech, and this episode is for all of our listeners, but especially our friends who are taking AP Government and Politics, because this is one of the Supreme Court cases. Dr. Carice is back with us. So, Dr. Carice, the Schenck versus U.S. case on First Amendment right to freedom of speech is over a century old. Why is it important for us to understand this case?
Thank you, Liz. Freedom of speech is an important, even defining characteristic of the American political and civic culture. It's present in our prehistory, so to speak, in the colonial period. There's a kind of reference to it in the first article of the Constitution that members of Congress can't be questioned for any speech while doing their business in the houses of Congress. But this was a real complaint of the Anti-Federalists during the ratification debate, that many of the state constitutions had bills of rights and had explicit protections for speech, and that this, was a huge failing of the Constitution. And so the gentleman's agreement, so to speak, is struck at several of the ratification conventions that there would be a Bill of Rights protecting common law rights. Obviously, freedom of speech would be one of them. So it's James Madison who puts forward in the House the drafting effort of the Bill of Rights. And what was the third in a list of 12 amendments becomes ratified as 10 amendments right away. We call it the Bill of Rights. And freedom of speech is right there as it's the third right protected, so to speak, along with freedom of press. And so this is an important characteristic. On the other hand, there's not a lot of Supreme Court activity about freedom of speech until the 20th century. So one thing to remember here is that the Bill of Rights in the federal Constitution only restricts the federal government until the 14th Amendment gives the opening or suggestion that liberties and privileges and immunities will now be protected under the federal Constitution against the states. And it takes a while for the Supreme Court to develop this view that, the rights protected in the federal Bill of Rights against government action, federal government action, now are to be questions adjudicated in the federal courts against states that might have infringed upon these rights. So fast forward to the 20th century. The 20th century is a very busy time for the Supreme Court on freedom of speech cases, and it really does start, arguably, with this Schenck case, the Abrams case as well in 1919. And why is that happening? Because of what we call the First World War, the Great War. Another background, though, is that, we all know why Abraham Lincoln was assassinated. U.S. President McKinley was assassinated in the 1890s, supposedly by an anarchist. So there are political revolutions happening in Europe because of socialism, communism, anarchy, against what? Capitalism or what? What is this against? So there are laws that are being passed against syndicalism. Say that fast 3 times. Criminal syndicalism to overthrow governments, and against anarchy and such things. So this is the Schenck case arises out of the Great War, as it was called at the time, the First World War, speech that was opposing the war by opposing, telling young men not to respond to a draft notice, not support the war. And The Supreme Court at the time in 1919, and a prominent justice here is Justice Oliver Wendell Holmes Jr., sort of a storied figure on the court, is working to figure out how to, protect speech, but also to recognize that governments, the federal government, the state governments, have legitimate concerns about public order and public safety in wartime. So the case is decided in 1919 after the war is over, but the case arises from activity during the war. And one of the paradoxes here is that Schenck versus the United States, Schenck loses the case. The speech is not protected under the First Amendment of the federal Constitution, but Holmes, writing for the unanimous court, begins to work out this idea that there is a legitimate concern here about giving governments too much leeway to restrict what's political speech. And for goodness sakes, what's America about? America's about political debate and political liberty and speech. So Holmes, for the court, uses language which suggests a move toward a more protective Supreme Court legal doctrine, a way of interpreting the free speech clause in the First Amendment. So I'm going to read this language. The question in every case is whether the words at issue, the words used, are used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Being able to sustain a war effort during wartime and political order and sustain the whole republic, right? These are legitimate aims of Congress and the president. So do the words used pose a clear and present danger to those legitimate concerns? Are they of such a nature themselves or the circumstances, right? That's a more speech protective standard than the traditional standard under the common law, which had held sway during most of the 19th century. That did the words have a bad tendency? It's gives a much broader sweep of authority to a state government to say, these words are headed toward bad things. Bad things could pretty easily happen from these words. It's very vague, very broad. So this is tightening it up in a more speech protective way. But on the other hand, Schenck loses the case. Then a couple of years later, Holmes and Justice Brandeis start to dissent in these cases. And they're insisting, you misunderstood what the clear and present danger test meant. We interpret it differently. We don't think the speech in this case, criminal syndicalism, communism, anarchy, whatever it is, this is not posing a clear and present danger to undermining the government or wasn't in those later cases a war effort. And so I would put it this way, an important seed has been planted by Justice Holmes and Justice Brandeis joining him to say there should be a more speech protective interpretation of First Amendment freedom of speech. And it takes time. And eventually, clear and present danger itself starts to have the effect that it protects speech. One of the cases many decades later that's important is in 1969, Brandenburg versus Ohio, which still makes reference to the clear and present danger standard, but in a way the court is moving beyond it by saying that itself is not protective enough of freedom of speech. So in the Brandenburg case, the court makes a ruling 8-0 that speech would have to be inciting imminent lawless action. And it would have to be likely to incite or produce such action for a state government or the federal government to say that speech is not protected. So it's a much tighter definition. It's building on clear and present danger, but it's much more specific. And merely advocating some action. I think this government ought to be overthrown because I don't know, egg prices are too high, or they're sending us into a war that's a horrible, whatever it is. If I'm just standing in a public park or whatever, the various ways of interpreting this imminent lawless action, inciting imminent lawless action likely to happen. The circumstances can involve very strong, violent speech about political issues, and the Supreme Court, from the 1950s onwards, starts to be very protective of speech, even if state and local governments, police forces are saying, "Hey, wait a minute, mob violence could break out here, or we're in the middle of a war." When the Brandenburg case is issued, it's not particularly about the Vietnam War, but a war is going on in Vietnam or in the Cold War. So again, the earlier doctrine, clear and present danger, is no longer the Supreme Court doctrine, but it did shift the Supreme Court's thinking and had therefore a significant legacy.
And to be clear, because I know that when students learn this case, they usually learn about the analogy that Holmes used about, like, you can't yell fire in a crowded movie theater, right? He was giving kind of this hypothetical example to show what clear and present danger is, because if you yell fire in a movie theater, you're creating panic. Like, this can create something that can be harmful to people. But again, hypothetical thing here. But we then move toward this more kind of stricter standard in Brandenburg of the imminent lawless action. So the formulation by the Supreme Court of a principle or a doctrine about clear and present danger, kind of shifting that to public safety and sustaining our republic, speech was protected unless it was judged to pose, again, such a danger. Fire in movie theater, again, very hypothetical. So now it's advanced for freedom of speech at the time, even if the court later decided it gives the government too much power to suppress speech. I mean, this feels like, where is the kind of line of free speech that can be suppressed, that we should allow? This is incredibly complex.
It is complicated,
right?
It is complicated. So one of the issues in the background here is the separation of powers principle.
Yeah.
Shouldn't the political judgment of state legislatures and governors over states have the police power for health, safety, welfare, morals in their states. And then shouldn't the political judgment of the Congress and the president be allowed to judge what's required for public order and, in a way, for kind of public morality, sustaining the republic? Who appointed these federal judges, small in number, right, from district judges to circuit appellate court judges to the 9 Supreme Court justices? Who appointed them emperors to overrule the judgment of these political figures who know more directly and just know more, period, in total substance awareness about our political and civic culture and what might be a danger to imminent lawless action? Why should they be second guessing the judgment of police and prosecutors and mayors and governors and federal officials? So there's a separation of powers issue. During the 20th century, the Supreme Court justices themselves have a greater level of confidence that First Amendment statement about freedom of speech has a clearer meaning in our minds than perhaps some earlier courts understood it to have, and it empowers us as justices to be more speech protective than earlier courts had thought. And the state governments and the federal government are just going to have to deal with it. Now there are complications, of different technologies for speech. It's not just being in a movie theater or a public park or even a newspaper, freedom of speech and freedom of the press, but with the internet. So radio and television, of course, complicated things, but now the internet and social media. So these are really perplexing questions for interested, informed citizens to be thinking about.
So when we look at those kinds of things, what are some of those continuing issues or debates about freedom of speech in the courts and constitutional law and really in American public culture that informed citizens need to understand?
Well, I'll pick just 2 of them. One is an interesting development in our political and civic culture later in the 20th century and into the 21st century, with the principle of equality being important, and especially after the 1960 immigration law changed, people from all kinds of cultures beyond Western Europe immigrating into the country from all over the world and different civilizations, concerned that certain kinds of speech could be harmful, bigoted, but actually harming people by the way you talked about someone, their race or their sex or their gender or their sexual identity or a civilization or cultural, religious term. And so speech codes developing, in effect, in schools, university public campuses, elsewhere. And so this raised First Amendment free speech issues. Where does First Amendment say that I can't say something rude? Right. I mean, so during the 20th century, the court developed these very strict categories. Okay. The Chaplinsky case from the 1940s. If you use fighting words, if I get right in your face and I start saying terrible things about, I don't know, whatever, women, or you're a Yankee, I know you're a Yankees fan or whatever, right? If I get right in your face and start shouting at you, the 1940s Supreme Court case said, you expect Liz to be able to want to punch me. Right. And who knows, a mob, riots or whatever. Right. So, fighting words are not protected. And obscene speech, well, that gets complicated precisely what obscene speech is. We just talked about imminent lawless action. Clearly false libelous speech, not protected. That gets complicated with, well, what if they're political figures? Can't you say just about anything about a political figure that's political speech, right? Even if you know it's a lie. But then this other category came up about sort of equal dignity for all Americans. And if I say something that's bigoted about somebody's religion or their race or racial characteristic, shouldn't I be prevented from saying that in a school setting, in a campus setting? So I just want to mention one very interesting case from 2017. It's the case of Matal versus Tom. And this is an Asian American rock band, music band, Asian descent, and they call themselves the Slants, talking about their facial characteristics, and they want to make a point out of it. But there's a federal rule. It's a patent and trademark rule that you can't patent or copyright anything under the federal government if it's seen to be derogatory toward a particular racial group, and there's other language. And so the Slants had applied for a trademark patent of their name. We don't want some other band or somebody else, selling merchandise or whatever using our name. And the federal agency involved turned it down. Under this code, we can't protect this. They took it to the Supreme Court and they won. Very strong ruling for the Supreme Court. Say, sorry, And now it did help the case that they were of that racial group that was supposedly being protected. But the court gave a very stirring affirmation of freedom of speech. Sorry, in a constitutional democratic republic like ours, with all this pluralism, First Amendment does protect speech that will be seen as harmful and bigoted or whatever. And that's just, you've got to be tough. You got to deal with it. Then a second category I'll mention that's really hasn't been entirely sorted out, but it's constantly being discussed in political speech debates and laws, is about social media and about the internet and about the general legal framework we have had for decades now about the internet, which basically protects the providers of these social media platforms. They're not liable for the speech, writing, or video of people on these social media platforms. And it stands to reason that because the internet has grown more and more and more dominant in our political discourse, that of course there are people advocating to Congress. This is crazy. There's all kinds of false speech and all kinds of speech that leads to harmful action, political violence included, assassination attempts or actual assassinations of political figures that are traceable to internet, social media, platforms and chat groups and things like that. So it just stands to reason that these requests would be put in front of Congress, and members of Congress would be deciding should it be put forward a bill that addresses these questions. So stay tuned about those debates.
I love that you brought up Matal versus Tam because my students loved that case. We were actually studying it while I was out, and they were doing a moot court on it. This is before the Supreme Court had decided, and they were tweeting about it. And Simon Tam actually came in and started interacting with my students while they were live tweeting. But it was such a cool case to go through with students to talk about, the disparagement clause and, what it originally meant and, what they're trying to do with it. So I think free speech cases, especially with students, are so interesting. And I'm glad that we were able to talk about Schenck v. US today because it does kind of set the groundwork. Even though it's not the standard used today, it still sets the groundwork for all of these cases. And you're right, man, social media, I will be very interested to see how AI starts to play into lot of these things when we talk about speech. But this is why we do the things we do, because they're interesting and they don't always have a black and white answer.
Yes. And for us as educators, this category of hate speech, right, which does not have legal standing. There's no court that's going to, under these 21st century Supreme Court doctrines, there's no court that's going to shut down somebody's speech on the basis of this was hateful speech, right? Because it's not fighting words and it's not incitement to imminent lawless action. It's, sorry, this is the nature of our political and civic culture. We are free to say that was hateful, stupid, bigoted speech that you just used. We're free to respond and say, you ought to apologize for that, or you ought to be ashamed of that, or et cetera, right? But there's no legal recourse that you can take about. And so it then becomes a difficult question in educational settings.
Yes.
What policies can there be in schools? What policies can there be in private colleges and universities, in public colleges and universities that are more directly under the First Amendment, et cetera?
Yeah. And we do have a really good episode with Professor Eugene Volokh on, I asked him the question about hate speech because it's not actually a doctrine. And we are in upcoming episodes going to talk about students in free speech. And actually we have Mary Beth Tinker, who is a Supreme Court petitioner, who is going to be on our podcast talking about it. So Dr. Crease, again, thank you for laying the groundwork for this specific amendment, and this case is greatly appreciated.
Great. Thank you, Liz.
Thanks for joining us on another episode of Civics in a Year. If you enjoyed this episode, be sure to subscribe and share it with someone who cares about a constitutional republic as much as you do. For more episodes, resources, and updates, follow us on social media or visit us at civics.asu.edu. Make sure to check out the show notes for any relevant links. Special thanks to the United States Marine Band for their performance of the Stars and Stripes Forever. Let's keep building a stronger constitutional republic, one episode at a time.